Mr. Speaker, on September 29, 2025, the Committee on Ethics and Privileges, upon a unanimous vote of all members present, there being quorum, acquired jurisdiction over the verified complaint docketed as Committee Case Number 3, entitled Representative Ronaldo V. Puno et al. Versus Representative Francisco Kiko A. Barzaga of the 4th District of Cavite, for violation of Section 141A, Rule 20 of the Rules of House of Representatives on the Code of Conduct, Section 4C of Republic Act 6713, or the Code of Conduct and Ethical Standards for Public Officials and Employees, Article 142 of the Revised Penal Code, and conduct prejudicial to the best interest of the service. It likewise determined the sufficiency in form and content of the sworn complaint. Hence, pursuant to Section 2E, Rule 1 of the Rules of Procedure of the Committee has considered the sworn complaint, and the Committee has the honor to inform the House of its findings and recommendations. Mr. Speaker, the Committee on Ethics and Privileges Secretariat received on September 17, 2025, a verified complaint dated September 16, 2025 against Representative Francisco Kiko A. Barzaga of the 4th District of Cavite for alleged violation of Section 141A of the Rules of the House, Republic Act 6713, otherwise known as the Code of Conduct, Section 142 of the Revised Penal Code, and conduct prejudicial to the best interest of the service. The complaint has 25 pages, including the verification and a certification of non-forum shopping. It was signed and filed by 29 complainants, namely Representatives Ronaldo V. Puno, Jeffrey P. Ferrer, Ronaldo M. Valeriano, Brian S. Yamsuan, Nico Raul S. Daza, Christopher Sheen P. Gonzalez, Augustina Dominic C. Pancho, John Gesnil L. Yap II, Rosalie A. Salvame, Alexandria P. Gonzalez, Antonio A. Ferrer, Sun J. Shimura, Alfredo D. Marañon III, Lawrence R. Defensor, Dimsar M. Sali, Miguel Luis R. Villafuerte, Vicencio Renato Luigi R. Villafuerte, Franz S. Pumaren, Karen Hope Flores Garcia, Maria Angela S. Garcia, Antolin A. Oreta III, Carlos A. Loria, Crispin Diego D. Remulla, Romeo M. Acop, Alpelito M. Bascug, Jerry Evangelista Perez, Adrian J. C. Advincula, Edibong G. Plaza, and Jennifer Karen A. Lagbas. These all 29 complainants are members coming from the National Unity Party, a registered political party in the Philippines. The complaint alleged that on 11 and 12 of September 2025, respondent violated and continued to violate, by means of his official social media platforms, the established standards of conduct for members of House of Representatives. The respondent posted statements on his verified Facebook pages, Congressman Kiko Barzaga and Kiko Barzaga Official, scurrilous attacks against government institutions and officials, which constitutes conduct unbecoming of a member of Congress. The complainants alleged that these social media posts in his verified Facebook pages contain language and imagery that employ derogatory and inflammatory rhetoric against government institutions, use vulgar and inappropriate language unbefitting a public official, promote divisiveness and undermine public confidence in government, and violate standards of decorum expected of members of Congress. The screenshots of the said posts, constituting 24 pictures found in said social media pages, were included as annexes by the complainants in their verified complaint, which later marked as their exhibits. Complainants admitted that while some of the posts were posted prior to Representative Barzaga's assumption as a House member, the crude and considerably lewd pictures remain posted and publicly visible despite his election as a district representative, which now bear the congressional title Congressman Kiko Barzaga. Complainants alleged that by allowing the pictures and what it depicts to remain public on his social media accounts, Representative Barzaga effectively republished the materials as part of his current conduct as a House member in the present Congress. The public posts have been reshared multiple times, thus placing the government and its officials in ridicule and rendered them objects of public mockery. The complainants alleged further that the totality of the conduct of Representative Barzaga constitute 4 causes of action. Number 1, violation of Section 141A, Rule 20 of the House Rules. 2, violation of Section 4C of Republic Act 6713, otherwise known as the Code of Conduct and Ethical Standards of Public Officials and Employees. 3. Violation of Article 142 of the Revised Penal Code. And 4. Conduct unbecoming of a member of the House and prejudicial to the best interest of the service. Complainants sought that the committee find Representative Barzaga guilty of violating Rule 20 of the House Rules of House of Representatives and Republic Act 6713 and impose upon him appropriate sanctions as may be provided by law and the House rules. Complainants likewise sought that the committee direct the respondent to refrain from similar conduct in the future. Mr. Speaker, on October 7, 2025, Respondent Representative Barzaga filed his answer to the verified complaint. Respondent denied all allegations and sought the dismissal of the complaint. His core defense is that the questioned Facebook posts constitute protected political speech made in good faith as part of legitimate public discourse. He further contended that the posts merely constitute expressions of opinion of matters of public concern that is protected under Article 3, Section 4 of the 1987 Constitution and are part of the legitimate exercise of a legislator's oversight and representative functions. He argued that none of the cited acts rise to the level of ethical misconduct, sedition, or conduct unbecoming of a House member or even prejudicial to the best interest of the service. He further stated that there is no substantial evidence to support the allegations which are mere mischaracterization of the respondent's action. Committee deliberations, determination of jurisdiction, and substantial compliance with form and content of the complaint. Mr. Speaker, in an executive session on September 29, 2025, the committee held its initial deliberation on the sworn complaint and, by a unanimous vote of all the members present, the committee acquired jurisdiction over the subject matter and determined that the sworn complaint substantially complied with the requirements of Section 24 on form and content of a sworn complaint. Thereafter, the committee sent a transmittal notice containing the formal charges to Representative Barzaga, furnishing him a copy of the sworn complaint and the committee rules of procedure. The committee directed respondent to file his response within 10 calendar days from receipt thereof, furnishing copies to the complainants. Initial review and attempt at conciliation. Mr. Speaker, during the conduct of the initial review on the case during the second regular meeting of the committee on October 13, complainant Deputy Speaker Puno on behalf of the other 29 complainants presented their case before the committee, citing the case hinges on 4 causes of action and that the evidence for the causes presented were already included in the complaint. On the part of the respondent, Barzaga, his counsel, Attorney Villa, stated that the respondent will not be making any more statement other than those mentioned in the respondent's answer. The respondent came in late during this meeting and was able to arrive only after his case. Thereafter, the committee decided to create a subcommittee on conciliation composed of 5 members, 3 from the majority and 2 members from the minority, namely Representative Domogan as presiding officer, chairperson, Representative Tanwatco, Representative Garcia. For the minority, Representative Cheljokno, and Senior Deputy Minority Leader Egay Arise. In the special meeting of the Committee on Ethics held on November 19, 2025, Representative Domogan, the presiding officer of the Subcommittee on Conciliation, reported that only the complainants submitted their manifestation of unwillingness to undergo conciliation. On the other hand, respondent did not submit any written manifestation and instead verbally relayed his unwillingness to enter into conciliation. During the meeting, the respondent did not further comment on the matter. Instead, when approached by the members, respondent signified his unwillingness. Representative Domogan then considered the conciliation terminated and closed. Thus, the committee terminated the conciliation proceeding and decided to continue with the initial review of the case. During the deliberation, the pleadings submitted were considered pieces of evidence on record by the parties as follows. For the complainants, verified complaint of the complainants dated September 16, 2025, including 24 annexes. Number 2, complainant's reply to respondent's answer dated October 6, 2025. Number 3, manifestation dated November 6, 2025. For the respondent, he provided an answer to the verified complaint dated October 6, 2025 with 1 annex. There being no additional submissions from the parties, the committee terminated the initial review on the case and decided to proceed with the formal adjudicatory hearing on the alleged improper conduct or violation committed by the respondent on the basis of Section 31 A, paragraph 3, rule 6 of the committee rules, which provides that further committee action is appropriate because the alleged improper conduct or violation is within the jurisdiction of the committee, and there is reason to believe that the alleged improper conduct or violation may have occurred. The committee set the formal adjudicatory hearing on November 24, 2025, where the chairperson directed the parties to submit to the committee the documents enumerated in Section 40B of the committee rules on or before the scheduled adjudicatory hearing. The parties were notified of the schedule in open hearing. Mr. Speaker, the committee conducted the adjudicatory hearing on November 24. Present during the hearing were complainant representatives Daza, Pumaren, Perez, Valeriano, Remulla, Lagbas, Ferrer, Oreta III, Loria, and counsels Attorney Lobo and Attorney Lo. However, both respondent, Representative Barzaga and his counsel, were not present and instead filed an urgent motion for postponement only minutes prior to the hearing. The motion for postponement was denied by the committee after due deliberations. In addition, the chairperson, pursuant to Section 40F of the committee rules, ruled to deny the motion of Representative Barzaga in his manifestation and motion dated November 20, 2025, to call Representative Advincula as one of the complainants as his witness on the ground of irrelevancy to the subject matter of the case. Upon the commencement of the formal hearing, complainants, through counsel Attorney Lobo, manifested that they will not be submitting additional evidence for the complainants and will adopt the verified complaint, reply, and manifestation as their exhibits. The complainant had their exhibits marked accordingly as follows. Exhibit A, verified complaint dated September 16, 2025. Exhibits A1 to A24, social media posts of Representative Barzaga with their respective links. Exhibit B, reply to respondent's answer dated October 6, 2025. Exhibit C, manifestation dated November 6, 2025. Mr. Speaker, the committee resolved to set the continuation of the adjudicatory hearing on the case Wednesday, November 26, 2025, with notice to respondent Barzaga that he should personally appear with or without counsel, with stern warning that failure to appear will result to a waiver of his right to cross-examine the complainants and for the committee to have its final determination under Section 41, Rule 7 of the Committee Rules of Procedure. Thereafter, Mr. Speaker, the chairperson issued an order directing both parties and their respective counsels to be present in the continuation of the adjudicatory hearing set on November 26. On November 26, the committee continued its adjudicatory hearing on the case through special meeting. Complainant Representatives Valeriano, Daza, Oreta III, and their counsels, Attorneys Lobo and Marsigan, and the respondent, Representative Barzaga, and his counsel, Attorney Villa, were present. The committee approved the prayer of the manifestation and motion of the complainants to limit the number of their witnesses to be presented for cross-examination by the respondent to Reps Daza and Valeriano. The complainants presented each of the 24 subject social media posts alleged in the complaint and explained to which particular causes of action each post pertained. Respondent Barzaga and his counsel conducted the cross-examination to witness Representative Daza. However, since both respondent and his counsel have been conducting cross-examination alternatively, upon motion by Representative Jokno, duly seconded, the committee decided that only the counsel of Representative Barzaga should conduct the cross-examination of Representative Valeriano. The complainants waived their right to conduct redirect examination, and instead, both parties were given their respective final statements, after which Representatives De Lima, Acosta, Abalos, Abante, and Guerin propounded clarificatory questions directly to respondent Representative Barzaga. The committee then terminated the formal adjudicatory hearing. After exhaustive deliberation on the matter, and with the adjudicatory hearing having been terminated, upon a unanimous vote of all the members present, there being a quorum, the committee has concluded that a violation of law, rule, or regulation of the House relating to the conduct of the House member within the jurisdiction of the committee has occurred. The committee found that there is substantial evidence and that the violation has been proven, warranting imposition of one of the disciplinary actions listed in paragraph B of Section 52, pursuant to Section 41, Rule 7 of the Committee Rules. On December 1, 2025, Mr. Speaker, the committee, in executive session, unanimously approved the draft committee report containing its exhaustive report on the deliberations conducted, its findings and conclusions on the arguments raised by both parties, and its recommendations to the House of Representatives with amendments subject to form and style. Mr. Speaker, the sole issue to be resolved is whether or not Representative Kiko Barzaga committed any acts of misconduct that constitutes disorderly behavior which may reflect upon the House of Representatives when he posted, retained, and failed to remove the subject social media posts in his Facebook accounts. Mr. Speaker, the committee is bereft of jurisdiction to determine criminal culpability under Article 142 of the Revised Penal Code inciting to sedition. In Article 142 inciting to sedition, the penalty of prison correctional in its maximum period and a fine of not exceeding 2,000 pesos shall be imposed upon any person who, without taking any direct part in the crime of sedition, should incite others to the accomplishment of any of the acts which constitute sedition by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end. In their complaint, Mr. Speaker, complainants admitted that while they are not filing a criminal complaint, the sedition-like character of subject social media posts invites dissatisfaction and arguably stokes violence and uprising, weakens the confidence of the public in lawful authorities, and aggravates the misconduct complained of. Such posts contain scurrilous libels against the government and may incite disaffection of the public and may erode loyalty to lawful authorities. Additionally, Mr. Speaker, the language used equates the government to authoritarianism or dictatorship, which can undermine public confidence. For his part, Mr. Speaker, respondent argued that Article 142 do not constitute seditious behavior, nor do they evince any intent to undermine lawful authority. On the contrary, respondent stated that the posts were made in good faith and in the legitimate exercise of his duty as a public official, being a legislator to promote transparency, accountability, and civic awareness. He added that far from inciting discontent, the posts actually encourage informed discourse and responsible citizenship. Mr. Speaker, the committee resolves not to belabor discussion on this matter, since the committee, being an administrative body, is bereft of jurisdiction to determine possible criminal culpability, if any, of the respondent on the statements posted in his social media accounts. Allegations of inciting to sedition should be proven beyond reasonable doubt in an appropriate judicial proceeding. Nonetheless, Mr. Speaker, this committee is firm that while the acts alleged may be denominated as criminal offenses, the committee is not divested of its duty under the Constitution and the rules of the House of Representatives to recommend disciplinary action if the acts likewise constitute misconduct, disorderly behavior, or violation of the House rules. This is especially true if the misconduct reflects upon the dignity, integrity, and reputation of the House of Representatives. Mr. Speaker, the House of Representatives has the power to discipline its members. The Constitution provides the power of the House of Representatives to punish its members for disorderly behavior and other contempts of its authority, as well as the power to suspend or expel a member for any cause which renders a member unfit to continue to occupy one of its seats. Section 16, paragraph 3, Article 6 of the 1987 Constitution provides, each House may determine the rules of proceedings, punish its members for disorderly behavior, and, with the concurrence of 2/3 of all its members, suspend or expel a member. A penalty of suspension when imposed shall not exceed 60 days. Mr. Speaker, the power to discipline is a power of protection, and the Legislative House is given the power to protect itself by the punishment of a member, according to one of the works of Hector de Leon, citing Cooley's A Treatise on Constitutional Limitations, a member who may be physically, mentally, or morally wholly unfit. He may be affected with a contagious disease or insane or noisy, violent, and disorderly, or in the habit of using profane, obscene, and abusive language. Mr. Speaker, Sections 141 and 142 of Rule 20 of Rules of the House of Representatives and the 20th Congress implement this legislative power of discipline. While there are express constitutional limitations on the power to discipline, namely, number 1, the only ground under which the House may discipline a member is for disorderly behavior. Number 2, the House may impose the penalty of suspension or expulsion only with concurrence of 2/3 of all its members. And 3, the penalty of suspension when imposed shall not exceed the period of 60 days. These limitations refer to the manner of exercise of the power to discipline. Mr. Speaker, there is no qualification in the constitutional legislative power to discipline that disorderly behavior must be related to official conduct or must be committed within the halls of Congress or in pursuance of legislative functions or in the course of legislative proceedings or activities. Mr. Speaker, the House of Representatives is the sole judge of what constitutes disorderly behavior. It is settled that the House of Representatives is the sole judge of what constitutes disorderly behavior, not only because the Constitution has conferred jurisdiction upon it, but also because the matter depends mainly on factual circumstances of which the House is in better position to determine, and for which cannot be depicted by black and white for presentation to and adjudication by the courts. What constitutes disorderly behavior as a ground for disciplinary action is concededly beyond the reach of the courts. While the Constitution is not explicit as to what constitutes disorderly behavior, jurisprudence dictates that the same is left at the sound discretion of the legislative body. In the case of Osmeña versus Pendatum, the High Court ruled that while parliamentary immunity guarantees the legislator complete freedom of expression without fear of being made responsible in criminal or civil actions before the courts or any other forum outside the congressional hall, however, it does not protect him from responsibility before the legislative body itself whenever his words and conduct are considered by the latter disorderly or unbecoming a member thereof. Respondent violated Section 141A, Rule 20, Code of Conduct of the Rules of the House of Representatives. Mr. Speaker, complainants alleged that respondents' act of posting disparaging content against the government and its institutions in a public sphere brings disrepute not only upon the respondent himself, but also to the entire institution. Complainants alleged the offensive posts constitute public misconduct, not private speech, because these were made through his official social media Facebook pages, and that the subject posts drag the House in disrepute, tarnish the institution's reputation, and undermine public trust. His continued publication of lewd and inflammatory content under the social media Facebook account Congressman Kiko Barzaga is a continuing ethical breach. Respondent, on the other hand, Mr. Speaker, alleged that Section 141 Rule 20 of the House Rules provides a general ethical guideline and is inherently subjective and must be interpreted in light of the constitutional guarantee of free speech under Article 2, Section 4 of the 1987 Constitution. He argued that the posts are not part of legitimate exercise of a legislator's oversight and representative functions. He added that there is no indication that the statements made online were made with malice, nor is there evidence that they were false or made with reckless disregard for the truth. Mere criticism of government or its institutions, even if harsh, does not automatically equate to conduct that reflects discredit on the House, absent clear proof of bad faith or intent to undermine the institution. Mr. Speaker, respondent repeatedly raised that the subject social media posts are made in exercise of his right to free speech and constitute expressions of opinion on matters of public concern. Freedom of speech and expression is not absolute and cannot be invoked in a proceeding before the Committee on Ethics and Privileges, whose jurisdiction is to scrutinize a member's conduct, especially so that the tool being used is by the nature of cyber communications like social media posts and Facebook, which has particularity on its speedy and wide-scale character. It is not a license, Mr. Speaker, to harm or defame others or to violate other rights. Mr. Speaker, if every member would invoke their right to free speech in every instance where an improper conduct is being investigated, there would be no instance when a member can ever be held accountable or liable. Although members of the House of Representatives are given a wide latitude in expressing their views on matters of public concern, they remain responsible to the House whenever they go beyond the threshold of conduct that is befitting for a congressman. Intemperate, distasteful, and incendiary language or conduct, even those uttered or committed outside the halls of Congress that tend to reflect discredit on the House and undermine its integrity, are subject to the disciplinary authority of the committee and the House of Representatives. Section 141A, Rule 20 of the House of Representatives Rules. Section 141, Code of Conduct. There is hereby established in the House the following Code of Conduct. A. A member shall act at all times in a manner that shall reflect creditably on the House. Section 141A obliges each member of the House of Representatives to act in a certain manner that conveys the honor and the dignity of the institution. Mr. Speaker, this ethical guideline directs members to conduct themselves with due regard to the respect and authority given to the House of Representatives as a body of esteemed representatives of the people. The inclusion of the phrase "at all times" signify that the conduct should not only pertain to a member's public life, but also his private life. Mr. Speaker, at the outset, it should be noted that the respondent in his answer did not deny ownership of the subject social media posts. In his testimony, Mr. Speaker, while he denied having exclusive control over Facebook accounts Congressman Kiko Barzaga and Kiko Barzaga, he disclosed and affirmed that the subject social media content were posted and published by his page editor under his instruction and approval. Attached to this committee report, Mr. Speaker, are the minutes of the said adjudicatory hearing. Mr. Speaker, respondent likewise confirmed that save in instances of miscommunication between him and his staff, all of the social media content he posts is with consent. This is likewise reflected in the minutes of our adjudicatory hearing, Mr. Speaker. With these, the committee considered the respondent to have a direct involvement and participation in posting and publishing these photos and content. Consequently, the committee had to look each of the subject social media posts alleged in the complaint to determine whether or not, in posting these content, respondent Barzaga committed any acts of misconduct or unparliamentary conduct which may reflect upon the House of Representatives or to the discredit of the same. Mr. Speaker, we find basis in the allegations of the complainants. The committee finds the subject social media post of the respondent to be inflammatory and with a tendency to unjustifiably incite public distrust with the government and the House of Representatives. Specifically, the committee finds the following social media posts to be violative of Section 141A, Rule 20 of the Rules of the House of Representatives. Exhibit A2, Exhibit A3, Exhibit A4, Exhibit A5, A6, A9, A11, and A14. Copies of these exhibits were distributed to each of the members. Mr. Speaker, the subject posts are not mere criticisms of the government, but reckless, unsubstantiated, offensive, general insinuations against public institutions and public officials that undermine the people's confidence in the government. The respondent argued that elected officials should be given wide latitude in expressing their views, even if critical of government policies. Mr. Speaker, political criticism, if made without basis, is simply heckling. In this case, respondent's conduct and remarks in his posts are not harsh criticisms against the government, but were made with malice, tending to insult and tarnish the image of the House of Representatives as an institution. We do not find respondents' blatant use of language suggestive of violence, public disorder, and turmoil to be sensible and intelligent political expressions one would expect from an elected legislator. The subject social media Facebook posts do not only suggest expressions of dissatisfaction to the government, but allusions promoting discord and tension among government institutions and leaders. Mr. Speaker, this committee shall not tolerate conduct that unjustifiably seeks to damage the reputation of the institution and undermine public confidence to government authorities in the guise of political expression. Expressions that include demeaning, derogatory, and denigrating language are not the kind of robust public discourse the House of Representatives should encourage among its ranks. Hence, the committee finds that the respondent had acted in a manner that tarnishes and damages the integrity of the House of Representatives and reflects negatively on the House members themselves, contrary to Section 141A of the Rules of the House of Representatives. A member of the House should always adhere to the Code of Conduct in the House of Representatives, since this was adopted by the House members themselves. Mr. Speaker, when a representative assumes his office, the representative swore to faithfully discharge to the best abilities the duties of an elected representative and of all others that the representative may hereafter hold. A significant part of these duties is to uphold the rules of the House of Representatives. The committee finds that the respondent failed to discharge this sworn duty not only to the institution, but also to the constituency that elected him to office. Mr. Speaker, respondent violated Section 4C of Republic Act 6713 and committed acts on becoming of a member of the House of Representatives. Complainants alleged that some of the subject social media posts exhibit obscene and inappropriate language, undermining public trust. Likewise, complainants alleged that respondent violated norms of behavior for public officials by acting contrary to good morals, public order, and public interest. During the adjudicatory hearing, complainants likewise pointed to the statement issued by the Philippine Commission on Women, condemning actions of the respondent which constitute a direct affront to the honor and dignity of women and a gross violation of Filipinos' trust. Section 4 of Republic Act 6713 mandates every public official to observe professionalism, justness, and sincerity, nationalism and patriotism, and commitment to democracy. Section 4C of RA 6713 provides norms of conduct of public officials and employees. A. Every public official and employee shall observe the following as standards of personal conduct in the discharge and execution of official duties. C. Justness and sincerity. Public officials and employees shall remain true to the people at all times. They must act with justness and sincerity and shall not discriminate against anyone, especially the poor and the underprivileged. They shall at all times respect the rights of others and shall refrain from doing acts contrary to law, good morals, good customs, public policy, public order, public safety, and public interest. Mr. Speaker, we have held that each member of the House of Representatives must not only be guided by the Code of Conduct, but also by the norms of conduct enunciated under RA 6713 or the Code of Conduct and Ethical Standards for Public Officials and Employees. Members of Congress are, after all, public officials and should be held to the same standards of conduct as any public servant. In fact, Mr. Speaker, members of Congress should be even held to a higher standard of conduct because they are elected and represent a constituency. The respondent, as a public official and an elected representatives, should be more circumspect in the use of social media posts, especially so when the account carries or bears his congressional title. In communicating and socializing through social media networks, respondent should bear in mind that when he communicates, regardless of whether it is a personal matter or part of his legislative duties, creates and contributes to the people's opinion, not just for himself, but of the entire House of Representatives. This is especially true when the posts are viewable not only by his family and close friends, but by acquaintances and the general public. When the respondent made and continue to make inflammatory posts in social media using his congressional title, he is not only representing his name and reputation, but also the name and reputation of the institution he is connected or associated with. Thus, when respondent showed these posts for public consumption, respondent placed himself in a situation where he and the status he holds as a House member may be the object of the public's criticism, ridicule, and mockery. Mr. Speaker, as a representative, he is expected to purport himself as a leader and a role model. A representative should carry himself or herself with the authority and the dignity of the position he assumed. A representative's language and conduct within and without the halls of Congress should carry the weight and significance of one who has been selected among many to represent the best interests of his constituency. The Constitution could have made it more explicit when it states in Section 1, Article 11, that public office is a public trust. Public officers and employees must, at all times, be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. We have stated that an elected official is burdened with these considerable obligations because the position carries the distinction in society. Public service requires no less. The committee finds the respondent to have breached the standards of propriety, professionalism, and decency when he permitted to retain posts showing lewd content, degrading views towards women, and ostentatious display of wealth in his Facebook page. Specifically, the committee finds respondent to have violated the tenets of justice, sincerity, good morals, and good customs enunciated in Section 4C of Republic Act 6713 by posting the following in his social media accounts: Exhibit A7, A8, A10, A12, A13, A15, A16 to 24. We agree with complainants that these are not conduct expected of a legislator. In addition, the committee finds respondents' act of retaining inappropriate posts, which admittedly were posted prior to assumption of his office in Congress, evinces deliberate and willful disregard of the institution's high standards and decorum and professionalism. As a legislator, he accepted the standards of conduct when he took an oath of his office as a member of the House of Representatives. The respondent cannot invoke his right to privacy as the social media posts are made public and are publicly accessible. These were made shareable and had been in fact shared multiple times. Following the principle in Vavares and Spouses Suzara versus St. Teresa's College et al., the respondent does not have reasonable expectation of privacy for subject social media posts because he has not manifested his intention to keep the post private or limited in visibility through the utilization of social media platforms' privacy tools. The fact that the subject social media posts were viewable by the public at the time the complaint was filed with the committee shows respondents' intent not to limit the subject social media post visibility and accessibility. Hence, respondent Barzaga cannot invoke his right to informational privacy. In communicating and socializing through social media, legislators, particularly House members, must bear in mind that what they communicate, regardless of whether it is a personal matter or part of his or her legislative duties, creates and contributes to the people's opinion, not just of the House member, but of the entire House of Representatives, of which he or she is a part. This is especially true when the posts of a House member are viewable not only by his or her family and close acquaintances, but also of the general public. In determining whether the social media posts by Representative Barzaga constitute disorderly behavior, this committee had to look whether these social media posts reflect positively on the image of the House of Representatives and its members. The statements reflect the dignity of his office as a representative of the people and his constituencies in Cavite, and the statements and social media posts reflect the values of the House of Representatives as an institution. The committee likewise took note of the statement of the Philippine Commission on Women condemning the scandalous behavior of the respondent and his disrespect of women's dignity. Ultimately, Mr. Speaker, based on these standards of conduct, the committee finds the social media posts in Facebook to be appropriated and unbefitting of a House member. Respondent's reckless, offensive, and irresponsible use of his social media platform tarnishes the name, integrity, and reputation of the House of Representatives. His deliberate choice to retain certain lewd, unprofessional, and inappropriate photos clearly shows bad faith. Respondent's conduct simply does not reflect the kind of principles and ideals the public expects of a public official, particularly a member of the House of Representatives. Mr. Speaker, after a thorough deliberation on the case, the committee finds that the actions of Rep. Barzaga in posting incendiary social media content through his Facebook accounts and in retaining and failing to remove publicly viewable, inappropriate, and indecent photos to be unparliamentary and unbecoming of a House member, taken in their entirety, the actions of Rep. Barzaga bring contempt, discredit, and disrepute to the name of the House of Representatives. His actions reflected negatively upon the dignity, integrity, and reputation of the House of Representatives as an institution of the members of the House individually and collectively. Consequently, the committee finds respondent Representative Kiko Barzaga of the 4th District of Cavite guilty of disorderly behavior by violating Section 141A Rule 20 of the Rules of House of Representatives, 4C of RA 6713, or the Code of Conduct and Ethical Standards for Public Officials and Employees, and by engaging conduct unbecoming of a member of the House, and recommends the imposition of the penalty of 60 days suspension from office without the benefit of salaries and allowances during the period of suspension, with a stern warning that repetition of similar misconduct will result to a more severe disciplinary action. In addition, Mr. Speaker, the committee recommends that the respondent Barzaga be directed to remove all 24 social media posts subject of this case within 24 hours from adoption of this report in the plenary. Mr. Speaker, let this be a reminder to all the members of the House of Representatives that as trustees of the people, we are expected to conduct ourselves in a manner that would reflect the dignity of our position in society and in public service. Let us be more circumspect in our acts and words and be mindful of the high standards of propriety required of us as legislators. Maraming salamat, Mr. Speaker.
Mr. Speaker, may we recognize Honorable Kiko Barzaga.
Honorable Kiko Barzaga is hereby recognized.
Okay, testing. Good. I wholeheartedly accept the decision of the committee, but I maintain my stance that President Marcos must be held accountable for his crimes. Too many people have died and too much money was plundered from the Filipino people for us to stand down now. Whatever punishment may fall upon me and others who stand against this president who has lost his constitutional mandate of serving the
Mr.
people is
Speaker,
inconsequential
point of
in
order.
relation to the amounts of lives
Mr. Speaker,
and
point of
futures
order.
that will be saved when
Majority
President
Leader.
Marcos leaves Malacanang. It took the deaths and imprisonment
Point of
Majority
order,
Leader.
Mr. Speaker.
to bring Marcos Sr. to
Point of
justice.
order, Mr. Speaker.
My punishment is only
Mr. Speaker, I would like to point out that as sponsor of this resolution, it is my time regarding this measure that we are deliberating right now. I would also like to put on record, Mr. Speaker, that the respondent has been given an opportunity to explain his defense at the proper forum, and we have accorded him that, Mr. Speaker. That is all, Mr. Speaker.